Today I'm going to talk about the case of the Spelucean explorers. This case was written by Lon Fuller, the legal theorist and philosopher, and it's a completely made up and hypothetical case. But I thought I'd do FIRAC on it because it brings up some very important issues in terms of interpretation of the law and in terms of interpretation of the cases, the facts, and combining all that. So in this case, we have the county of Stofield versus the Spelucean explorers. And I'm starting with the storytelling or narrative facts. These are the facts that we can remember the most, like closely. He says the defendants were a group of cave explorers who became trapped underground for 32 days. And they were cut off from the outside world and faced starvation as time passed. So they were in the caves, and it would have been very hard for them to survive without food. They had a very limited food and all that. And the reason I put this as a narrative facts is because this is just telling us what this case is about and what happened. So we know that the county of Stofield is versus the Spelucean explorers, the defendants. The legally dispositive facts are the facts that pertain directly to what facts we should use and how these facts are going to play out in case and all that. So in this case, when there were these explorers, they were stuck in the cave. They had a wireless radio. They were able to establish communication with the outside world. And then they had doctors who informed them that they would not be able to survive for another 10 days without a food. The victim, which is Roger Wetmore, while they were in the cave, they proposed using a dice to decide which member should be killed and eaten for others to survive. So the victim, Wetmore, who becomes a victim, he comes up with this idea, we need to survive. So all the defendants agreed to Wetmore's proposal. So all other people who were explorers who were there agreed to that, and Wetmore later attempted to withdraw. So as the time passed, the victim, Mr. Wetmore, Roger Wetmore, attempted to withdraw from the agreement before casting the dice, but the others refused to allow his withdrawal. Anyway, in any case, the dice was casted, and Wetmore was killed and eaten by the defendants. The death of Wetmore resulted directly from defendants' intentional killing. So they end up killing him and eating him because that's what happened. So these things are important. These are legally positive facts that occur here. Now, next issue is also this one here is another thing that I put as a legally dispositive fact, is that one of the member of the jury, when he came to the trial, one of the member of the jury who was also an attorney argued that they should have a special verdict. And the special verdict in this case would be that the jury finds the defendants were guilty of the crime charged against them, and then they found the defendants guilty, which based on these facts, but they also left for judge to implement what a death penalty, the punishment. What would be the appropriate punishment for that? They found him guilty based on the facts. The jury found him guilty based on the facts, and then the judge found him also agreed with the jury and found him guilty based on the facts. But the judge then sentenced them to be hanged, and to the law of our Commonwealth permitting him no discretion with respect to the penalty to be imposed. Well, so in this case, the jury based on the facts, found him guilty. They did not say, well, he should be punished or he should not hang, but the judge had to interpret that law and say, okay, the facts support the conclusion, and they should be put to death. And the judge could not use any discretion to disagree with the law. And now procedural posture, and this is where we kind of understand how the case, what happened in the trial court, what was appealed, what was the petition, and what did the court do. So this is, we are explaining a procedure under which this case was moving along. And mind you that this case is completely hypothetical case. So the Court of General Instances, Tofield Trial Court, found the defendant guilty of murder and sentenced him to be hanged, and with no judicial discretion available regarding punishment. That is, the judge has to apply the letter of the law. The law is written, the penalty, the punishment for this purpose is for them to be hanged. So that the trial court found that now the defendant's appeal by filing petition of error, claiming that the lower court made a legal mistake. So according to the Cornell Legal Dictionary and the Cornell Law School, they say a writ of error is an order requested by a party for a judge to reconsider the case. A writ of error is mainly used to correct an error of law, not a fact, and to assure that legal proceedings and judgments adhere to the correct legal standards and procedures. So here, what they're appealing is that whether it's not the facts, because we know that trial court and the jury agreed on the facts, but they are requesting that the judge who decided that made a error in interpreting the law. Like, we have to look at the law in a different way, and we will see how that goes. Now, so making sure that we understand petition of error. The Court of Appeals affirmed the conviction, likewise ordered the defendants to be executed. So the Court of Appeals didn't say, they found here that they agreed with trial court, and the trial court the trial court was right in applying the law, and this petition is not based on the facts. The defendants did not disagree on the facts of the case, but rather of an error of the law. And we will see what that error of the law, how it plays out in how the Court of Appeals, in this case, how the justices, the High Court, in this hypothetical case, disagree with one another. Now we're going to talk about the issues. So the core issue that I listed for this case is whether the defendants acted willfully when they killed Wetmore in a cave to survive and not to starve to death. So that is the issue. And then I also looked at a key word here, playing willfully, which is an adverb, refers to acts which are intentional, conscientious, voluntarily, and designed to achieve particular result. Now, in this case, this is the issue, the core issue, whether defendants acted willfully when they killed Wetmore in a cave to survive. And so did they, in other words, did they had with the intention of killing him? Did they ask, did they have a free will, meaning were they free, or was there anything else going on? Now, I also put the rule for this one, the key rule that is being interpreted in this case is whoever shall willfully take the life of another shall be punished to death. This is the main rule that the court uses to decide this case. Now, there's other issues that come up. They are more theoretical in terms of theory of law and jurisprudence, and I'm going to discuss them because Longfellow does a great job in bringing different issues in this hypothetical case. The next one you see, it says philosophical issue or merely a legal issue. So the reason I named this one is because if we are speaking hypotheticals, let's just say when Wetmore agreed to this contract, Did he accept when he agreed it? Is this when he accepted the contract, or can that contract still be cancelled before the dice is rolled? And I believe that if we were to accept this, the Wetmore should be able to cancel the contract because the dice was not rolled. However, the defendants did not allow him to cancel that contract. So whether cave explorers freely entered into a contract using dice to determine which individual is going to be killed. It seems like they have freely, because the victim came up with his idea and all that, but at the same time he had no he could not be able to cancel this contract. He was not able to cancel the contract because when he entered, and as a result he got killed. Now the rule that I believe that was applied here, it's called with the Latin cessante ratione legis, cessat lex ipsa. When the reason for the law ceases, the law itself ceases. So what this principle is saying, they had to create their own rule in the cave because outside they were outside of legal protection, and they were not able to help them. So this is where the society which they belong to, or jurisdiction that they belong to, is no longer applicable to them. They had to create their own rules, which is they created their own contract and acted based upon their own will and all that, which kind of reminds me of the case where when the Bush administration after the 9/11, when they imposed imposed the kind of not imposed, but they got some of the people from Middle East and brought them into Guantanamo Bay, and they listed them as non-combatants, and therefore avoiding of any issue of international, or me kind of removing them from that jurisdiction. So this kind of seems like it's similar. It's a kind of a jurisdictional issue, but my perspective on this is that you cannot make that kind of contract, even though you're stuck in a ground. If you, some people will say, well, you have to do what you have to do to survive, but again, that does not necessarily mean that you will not face the legal consequences of it. The next one that I looked at is, and then I phrased this one, whether it kind of is similar to this one, but it's different, because the other one is talking about a contract. This one is talking about jurisdiction. Whether the defendants fall outside the jurisdiction of criminal law because they found themselves unreachable by rescuers and protection of the positive law. So again, it goes back to the same rule, but the different issues I phrased in terms of jurisdiction. And in this case, the argument is that since they cannot be protected by this jurisdiction, since they are so far in a cave, this is where the law, again, this principle goes back to, this is where the law ceases, and then this is where the people who have found themselves in there, they need to create their own rules and in order to survive. So this is another thing that where does jurisdiction stop, and so that this could be applied. So here's the analysis here. One of the justices that was appealed this case, he says he applies the rule of whoever shall, which is 1A core issue, whoever shall willfully take the life of another shall be punished to death. Agrees with the jury and the defendants acted willfully, and the defendants acted willfully. The statute permits of no exception applicable to this case. So the statute is plain. They have to be put to death. This is it. This is the true penny. He cuts it short. This is the agreement. This is how one way of looking at it is. Now, the next few justices gets into kind of very interpretive statutory interpretation and construing a statute or misconstruing a statute in terms of this case. Now, here's the J. Foster, another Supreme Court justice, who proposes this idea of, again, the principle where the law ceases to become, where the law is no longer applicable. He says, when the situation arises in which the coexistence of men becomes impossible, then the condition that underlines all those precedents and statutes cease to exist. So he applies that rule, that Latin rule that I was talking about, this one. Cessante rationale legis, when the reason for the law ceases, the law itself ceases. So he applies that and says these people they cannot survive. And then he also says here, he argues, he says this is applying, we are not then accustomed to applying the maxim, cessante rationale legis, cessant in ipsa, but he says the believe that this is the case where the maxim should be applied. So he wants to apply this rule here, where the law, if there's no reason for the law, then the law itself stops. Now, of course, then he continues to argue. He says, now, of course, perfectly clear that these men did an act that violates the literal wording of the statute, which declares that he who shall willfully take the life of another is a murderer. So he kind of accepts this is the case. We know the statute is clear on that, but he is trying to make an exception to this statute, and he's looking for the purpose. So, but one of the most ancient bits of legal wisdom is the saying that the men who break the letter of the law without breaking the law itself. Every proposition of positive law, whether contained in a statute or judicial precedent, is to be interpreted reasonably in the light of evident purpose. And this is where the fascinating interpretation or the interpretation of a statute comes into question. So he's saying we can look at the plain language, but we have to look at what is the purpose of that. So, for example, shall willfully take the life of another. The purpose of this statute is also to deter people from killing people at the same time. So he's trying to reconcile the plain language and the statute, the plain language of the statute and the purpose of it. So he's saying, well, since these men were found themselves in impossible situation, they did break the letter of the law, but not spirit of the law, which means we should not apply the statute because the purpose of the statute is to deter people from committing a crime. And the way I understand this is that when these people get out of the cave, it's not like they're going to go killing people and eating them. And so this also goes back to very interesting debate that happened in 17th and 18th century. The philosophers that talked about state of nature and state of society, right? So this is where the Foster is going to bring us. Like, if we live in a state of society where the law applies, then I guess if we are to look at the flip side of this argument, is that we would say, well, plain language says you should not kill people, but because these people did not find them in a state of society, they were outside of that jurisdiction. The statute has to be interpreted in the spirit of the law, not in the letter of the law. So that's, and then Justice Foster continues to argument. And here is this one. When the assumption that men may live together loses its truth, it is obviously that in this extraordinary situation where life only became possible by taking of life, then the basic premises underlying our whole legal order have lost their meaning and force. This is again applying where the reason for the law. So here we have this extraordinary situation where the reason for the law disappears, and then it becomes a necessity, and this is kind of a, can you kill somebody by necessity? And also he talks about the defense of necessity. Premises underlying our legal order have lost their meaning and force. This is where the law stopped because the society couldn't do anything in trying to rescue these people. They were stuck in there. Some people even end up dying in course of trying to rescue them. So they are left to fend for themselves, and they can create the rules that they think is the most fit in the situation that they find themselves. And then he continues, his argument is long. So then Foster gives us some kind of this is, I call, analogous, or by analogy. He uses some other cases where in this case, like Commonwealth versus Tamor, is the defendant was convicted under the statute making it a crime to leave one's car parked in a certain areas. So if you park your car in a certain area, it's a crime, and the defendant attempted to remove this car, but it was prevented from doing so because the streets were obstructed by political demonstration in which he took no part and which we had no reason to anticipate. His conviction was set aside by this court, although this case is squarely within the wording of the statute. So he's saying, okay, we have this case of parking where he violated the law, but because he couldn't get to his car to remove it, he was prevented, and then we were able to put that aside. And then he continues to give another case here, Fechler versus Negas. There was a before the court for construction of statute which the word "not" had plainly been transposed from its standard position in the final and most crucial section of the act. So this is where what he's talking about here. This is where the legislature, they made a mistake, and they didn't put the word "not," which was supposed to be there, right? And what he is he says, no one was able to prove how the error came about, yet it was apparent that taking account of these contents of the statute as a whole, an error has been made, since a literal reading of the final clause rendered it inconsistent with everything that had gone before and with the object of the enactment as stated in the preamble. This court refused to accept literal interpretation of the statute, and in effect rectified its language by reading the word "not" in the place where it was evidently intended to go. So he's like, okay, so here's this case. We're talking about it in intention. And this is where Foster goes back to disagrees with a plain meaning interpretation of the statute. He says, okay, we need to, if like the word that was omitted here, "not," was actually put in there by the judges in order to make sense of this court. So you can fill in the gap. He's trying to say, in cases, and we have to look at the purpose, and we have to look at all that and interpret the law. And then in that case, we can just put the word that is not in there. So like we can say that there is the purpose of criminal law is to deter, but since these people were acting in a extraordinary situation, there's no deterrent effect. The arguments of the Justice Tadding, he talks about this Commonwealth Valjean. Though the case is somewhat obscurely reported, it appears the defendant was indicted for larceny of loaf of bread and offered as a defense that he was in a condition approaching starvation. The court refused to accept his defense, however, withdraws from the case. So he presents another case here where this guy stole a loaf of bread because he was starving, he needed to eat, or he was going to die. But the court decided, nope, we cannot accept that as the defense. You cannot break the law because you are hungry or you're starving or you're about to die. So they did not accept that. But at the same time, he abstains from making his decision, which, again, in this case, we see that you cannot you cannot accept that as a defense, because you had to break the law because it was necessary to break the law. So the defense of necessity was applied here. No, it was not, because even though you have defense of necessity, but the court did not apply it in this situation, Commonwealth v. Spelucean. Now, Justice Keene kind of responds to Foster, which the one I was just reading, this example here, and we know that Foster is saying we should be looking at the purpose of the statute. We should be looking at the letter of the law, but also at the spirit of the law, and that you can break the spirit of the law, you can break the letter of the law, but you're not breaking the spirit of the law. Justice Keene is actually offering a different kind of argument here. So it says, whoever shall willfully take the life of another shall be punished by death. Now, I should suppose that any candid observer content to extract from these words their natural meaning would concede at once that these defendants did willfully take the life. But then he quotes this, and then he is replying to Foster, which the one we were talking about. He says, instead, the Foster develops a familiar line of argument according to which the court may disregard the expressed language of statute when something not contained in the statute itself calls its purpose can be employed to justify the result the court considers proper. So this is where, this is where the end justifies means. This is what I mean. It's like, so we want to find these defendants not guilty, and therefore we're going to find a purpose. And the purpose of the criminal law is to deter. But in this case, there's no deterrence effect, because they haven't, the deterrence would not apply here. And the process of judicial reforms requires, so this is where arguments of Keene continues. This is the process of judicial reform requires 3 steps. The first of these is to define some single purpose which the statute serves. So he's saying, like, okay, so judicial process, we need to find the purpose of a statute. And then he says this is done, and then it's going to be very hard to find that single purpose, because different courts, different people might interpret that statute might find so many different purposes. And then the second step, he says, to discover mythical being called the legislature in the pursuit of that imagined purpose, overlooked something or left some gap or imperfection in his work. So he's like saying, okay, so now you have to go back. So when you find when you think there's a purpose, then you have to go, what purpose, who was writing this? And we know when the law is written, legislature writes it. So we have to look what purpose, what did the legislature intended to do with this statute? And he kind of mythical being called the legislature in pursuit of the imagined or overlooked something, or we need to fill up a gap, or what did the legislature wanted to do? And then last step is, of course, to fill in the blank thus created. So then the last step, once you find that there is a gap, or there is you have to reconcile, or you have to find a way of reconciling between interpretation of a statute, between plain language and the purpose of that statute. And this is where you fill in that gap, the gap filling, which is deterrence. So is there deterrence? No. So now it says, now the scope of this exception in favor of self-defense that has been applied by the court is plain. It applies to cases of resisting an aggressive threat to the party's own life. It is therefore too clear for argument that this case does not fall within the scope of the exception, since it is plain that Wetmore made no threat against the lives of these defendants and affirms the conviction of the defendants. So he's like, okay, so we don't have anything here that says that Wetmore made any threat or anything like that. So therefore, the defense of Self-defense does not apply because Wetmore was not threatening them, was not killing. This was all done. They acted based on their own intent, which in criminal law we have to have criminal mind and criminal act. We have here, they had the intention and they killed him. We have the act. We know that based on the facts that he was killed and eaten. So, and then he affirms the condition here. But he then concludes the clear-cut principle, and what he's talking about here, his clear-cut principle is the plain meaning of the statute. And he gives the supremacy. This is whether the legislature determines what the law is, not the judges. It says from the principle, so when we are talking about the principle, we're talking about a plain meaning. From the clear-cut principle, we're talking about which is the supremacy of legislative branch of government. So he's talking about legislature makes the law, and we have to follow that law. But we have to follow it as it's written, and it's in accordance with the plain meaning without reference to personal desires or individual conceptions of justice. So his argument here is that if we are going to interpret the law, we cannot go look at to find some kind of purpose or to find some kind of because we think that it was injustice, and we have to look at the law. This is the law, and you broke the law, and this is the consequence, and that is that. There's no if, buts, or thens, or anything like that. Which is an interesting argument. He strictly applies the law, and then he also affirms the Justice Keene. He affirms of the law court decision that these defendants are guilty and they should be hanged. Now, Justice Handing finds defendants not guilty and uses the case. Handy worked on years ago using analogous reasoning. Furthermore, I felt strongly that the plaintiff had to large extent brought the thing on himself. He knew how inflamed passions were about the affair and could easily have found another form of the expression for his views. So he's blaming the victim here. He's saying, okay, well, finds the defendant is not guilty, and he says, like, look, you came up with this idea, you're responsible, you did this, and you brought this on you. You provoked these people, you gave them the idea, and you provoked them, and you got them there. I do not agree with this because he initiated the idea, but then he tried to withdraw, and they would not let him. So he changed his mind, so into his defense, he changed his mind, and the dice was not rolled yet, and he was not allowed to withdraw from this idea. So in this case, still abstains. So Tadding, or another one, escapes from rendering his opinion, and the court affirms the decision of the trial court. Which, in my opinion here, so the defendants were found guilty, and they are no longer allowed to participate. They're found guilty, and they're going to be executed. Now, there's other issues that come up in this case as issue of clemency, and when can we give the clemency, or can we give them the commuted sentence? In this case, you couldn't give them the commuted sentence because the law did not allow that. The statute says you should be punished by death. There was no discretion, so the statute here did not allow for the discretion to be happen. But no, we know that in general, judges have discretion what kind of a punishment they want to impose. You can look at the circumstances under which the crime is committed. So then we can kind of commute the sentence, or say maybe 5 years or 10 years or something, or maybe commute the sentence to life in prison without a parole, or maybe life in prison with the parole not to be hanged. So there's a few ways that could have been done, even though that the statute here strictly says what it says, that these people have committed a crime. But my thinking is that we we have to look at the purpose, the legislature, and we have to try to understand it. But not in this case where the language is clear. If you kill somebody, you're getting death, and there's no you willfully you intentionally kill them. The person is dead. We have actus, we have mens rea, we have criminal act, we have criminal intent, and we have criminal mind, actus reus and mens rea, and that is that. So there could have been no filling the gaps here. This is not like where you have so many subsections and sections that then you try to apply as a section A applying to section B and all that. So in my conclusion, I think the court was right to apply the law the way it did, but at the same time, the judges do have a discretion to apply, whether to apply the law or not. But one thing I would like to, the clear-cut principle, yes, we don't want judges to apply the law, to invent the law or come up with their own law. But at the same time, you have to have some kind of reconsideration for the actions. Like here, where we are looking, and to a certain extent, Keane could be right about the words and the plain meaning of the words, and we have to look. It's a straightforward bang. You broke the law, and that's it. But we also have to look at the circumstances. We have to look at who are the victims, who is the victim, and are these people, these explorers. They were not criminals or anything like that before they went into the cave. They just went to the cave to explore. So we have to look at those two things. But at the same time, I'd like to come back to this idea and this is where I'm doing my own interpretation here. And so to further explain the Foster's argument here is that as I was referencing before, in 16th, 17th, and 18th century, we had philosophers who came up with the idea of state of nature, state of society. And what a Foster is applying here is that these people were living now in state of nature. They're no longer part of the state of society, and the law here no longer applies because they are left to fend for themselves and they had to fight for their own lives. That's why I think this argument could have been used to compute the sentence and to give a little less the punishment rather than fit it exactly the way the words were written in there, to kind of look at the case and all that. But overall, this is a fascinating case, and I really enjoyed doing this and reading it. And if you have any questions or any comments, please, you can post them down below. Thank you.